which may be found.
Under circumstances, it creates suspicion of the commission of any offence.
So, question, that is why Supreme Court says that suppose you come on the later part of the section, which creates suspicion of commission of any offence, meaning thereby, in your case, X has been raided. According to them, some incriminating material has been found as regards unknown source of income of A. So far, it is not evident from the reply or from your document which is written to the bank. There is nothing on record to suggest that any link is established justifying seizure of the accounts. Why I say so? Because the raid has taken place on
24/2/2016
और रेड हुआ और 24/2 को आपने सीज कर दिया अकाउंट। 24/2 की तारीख में ऐसा कौन सा मटेरियल था आपके पास में जो आपने 24/2 को ही चिट्ठी लिख दी कि आप इनके अकाउंट सीज कर दो, लॉकर सील कर दो?
Let me complete. The suspicion is called for.
नहीं मिस्टर काउंसिल, ये तो आप वो बात कर रहे हैं जो बात आपने 24 तारीख की बात समझी है। 24 तारीख को आपके पास क्या था?
24 तारीख को जब रेड हुई तो जितना मटेरियल मिला 11 प्रॉपर्टी
कहीं लिखा है कहीं पर?
ये जब्ती जो पंचनामा बनाया
नहीं, कहीं पे ये बात लिखी है कि वी हैव दिस सस्पिशन।
that is my humble submission that this is the difference between suspicion and the reason to believe.
वो क्या है? ये मूड कोर्ट वाली बहस ना करो, तुम ये हमें बताओ कि कहीं नहीं लिखा है तुमने। बिकॉज देखो, लॉ इज नॉट लाइफलेस एंड द पावर अंडर 102 इज नॉट एब्सोल्यूट, इट इज ऑलवेज सब्जेक्ट टू जुडिशियल रिव्यू। उसमें अभी हम जाना नहीं चाहते। अगर इफ यू गो टू दैट डिबेट, probably I may reach to a conclusion that is seizure is liable to be quashed. I may reach to a conclusion because if I can understand that after application of mine, after comparing the all balance sheet and other things, you reach to conclusion to go and for seizure, because we cannot expect any investigating agency to immediately order for seizure. अब उस पर भी नहीं जाना चाहते क्योंकि उस
ट्रांसफर हो गया, इसलिए वो सबमिट नहीं कर पाया। नया आया, उसकी कंप्लेंट हमने की उपायुक्त को, जो उसने मांग की थी, और उसके बाद
वही कह रहा हूँ ना कि जो जितनी देयर विल बी मेनी लेयर्स, वो खोलते जाएंगे तो आंच बहुत ऊपर तक पहुंच जाएगी। अब वो मैं चाहता नहीं हूँ करना, क्योंकि ये इट्स अ फिट केस टू इंटरफेयर ऑन द क्वेश्चन ऑफ पावर 102। If you then you run the risk, then I will not get into this aspect about the release of the property. हाँ नहीं, मतलब अगर suppose I find from their record that, because no doubt we are discussing 102, but it all depends upon the circumstances, and if he is able to persuade us that there are the documents.
Show one document.
No, Don't be overconfident. I'm telling you. Don't be overconfident. He is throwing a challenge. If we accept it and let us go by this, and we will see what can be done. ठीक है? आप भी बता दीजिए. If you want to go into this issue of the factor of suspicion and seizure, then both parties are in the risk. We do not know because we have not seen the record. Then we will examine the entire record. आपके पास केवल वो बैंक की चिट्ठी भर तो है और क्या आपके पास में? फिर हमको देखा सारा रिकॉर्ड देखना पड़ेगा जितना शुरू से आखिरी तक का है. अभी तो हम इसमें जा रहे हैं कि 6 साल तक इन्होंने कुछ नहीं किया. यहाँ से वहां फाइल चल रही है और आपका पैसा रुका है, इसलिए हम उसके ऑर्डर पे जा रहे हैं जिसने आपके ऑर्डर को आपको रिफ्यूज कर दिया है. आप बताइए क्या है, इनको आई विल ऑर्डर अकॉर्डिंगली. बट ये आप अपने क्लाइंट्स को बताइए कि दिस इज नॉट अप्रिशिएबल दैट फॉर इयर्स टुगेदर.
I went to the office, find out the, if I can say off the record, this is the fastest, one of the fastest cases which have reached the conclusion. One of the fastest.
I think one day, I think if this is the culture, work culture in Lok Ayukt office. Maybe this one day it may be found to be appropriate to close the office. What for? See, 6 years, 10 years, 12 years. If you take time to file charge sheet.
There are 8 districts. For 8 districts, there are
8?
hardly 8 investigating officers with no support system. They don't even have.
Then why should you not employ?
This is where the discrepancy.
What discrepancy? ये रोना तो हर जगह पे है.
Administration lies with the state government.
No, question here is that question. See, this is the time to ensure that the institution functions properly. If you are running an institution and if you do not get the proper, then you stop working. Then why you harass the people?
I was answering the query that what is going on.
No, but question here is see.
This
You,
cannot happen that you see in
अब now can we say is an excuse for us because we are short of judges, therefore we are not able to perform our work. We are supposed to perform our work, whatever staff we have, and we are doing it also. So that, and you are asking for the support of the ministerial staff or the investigating staff. You have the officers there, but why should question? See, this is the problem. The machinery functions if you really sit on it and ensure that it functions. Otherwise, but our worry is not about your functioning. Our worry or our concern is for the public at large. Now, if some person has been roped in and you know what kind of complaints are being sent to Lok Ayukt, this is an office which is used by many such people to settle their personal scores. I do not comment upon a particular case, but general feeling is if somebody is about to be promoted as head of the department, if somebody is about to be given a coveted posting, if somebody is about to be sent on some special assignments, there may be a well-decorated complaint. What happens to complaint is immaterial. But once there is an order to issue notice, that is sufficient proof to malign the entire service record of that officer who was about to take off with some prestigious assignments as a token of his good services or unblemished service record. Most of the cases. And if you check up the statistics, find out how many complaints you have received in how many complaints you have issued notices, you will get to know. And how many cases, what have you done? If you call for this record, those figures will speak for themselves. What kind of and what quality of work is going on. And you have been created only to checkmate corruption. A special police establishment. Now, I sometimes find very amusing. In every case, we find SIT is constituted, and that officer heading the SIT does not know the meaning of mark or meaning of FIR. He is not able to answer each and a single question to this court. He walks with the accused to the relative's office, finds house locked, comes back, makes an endorsement in his namcha. I don't want to get into that, but all said and done, if the government is not cooperating, you ensure it, the government does it. Otherwise, unnecessarily, you invite criticism. So, but see, we all, High Court, or for that matter, any institution which is for the public, we are expected to honor the repose and honor the trust and faith they repose on us. If we do not respond to that, what would be the image of the institution? Now, in this case, for 6 years you have stopped the operation of the account. And look at the situation. Whatever amount is lying there, it is as it is. If that was invested somewhere, either by you in the form of fixed deposit, I can understand that you have deposited the amount in fixed deposit, it is earning some money on this. Or if it was given to him on a security satisfying your officer, it could have been invested. But why should we bring us to everything to a standstill? Neither you are moving ahead, nor he is able to use his funds. But for the court's intervention, he is nowhere. See what the trial court writes. अन्वेषण चल रहा है. Without little understanding, अन्वेषण कब से चल रहा है, किस स्टेज पे चल रहा है, क्यों चल रहा है. There is nothing total innocuous order, total evasive in nature. We cannot render 451, 457 as a mere ministerial power. It's a judicial power, and one has to exercise the power consciously, so that people do not say that law is lifeless. It's full of life, and the order should be vibrant enough to ensure that law is given full respect. Anyway, you find out and let us know. कब रख दें इसको? Day after tomorrow? Yes, hearing parties.